Thank you for watching this video, which is number 3 and is the last one for this week. Another hot topic is sexual harassment. Sexual harassment is unwelcome verbal, visual, or physical conduct of a sexual nature that is severe and affects working conditions or creates a hostile work environment. Sexual harassment can occur between a boss and a subordinate, among co-workers, and when non-employees have business contacts with employees. Two basic types of sexual harassment have been defined by EEOC regulations and a number of court cases. They are defined as follows. Number 1, quid pro quo, which comes from the Latin and means this for that, is harassment in which employment outcomes are linked to granting sexual favors. An example of this type of harassment could be a supervisor telling a subordinate that if he or she goes out on a date with him or her, they will get the day off that they have been requesting. The employment outcome can either benefit or affect the conditions for the employee. The second one is hostile work environment, which is harassment in which an individual where performance or psychological well-being is unreasonably affected by intimidating or offensive working conditions. An example can be an employee feeling offended because two of his or her co-workers look at and laugh at pictures of naked people during working hours. Even if the pictures are not intended for that third person to see them, this can still be considered harassment because that third person is being exposed to that situation in the workplace. Human resources professionals can help companies avoiding liability if they take reasonable care to prohibit sexual harassment. Some of the best practices include: number 1, establishing a sexual harassment policy that aligns with the law and protects employees of being exposed to harassment. Number 2, communicate the policy regularly. Such policies should be presented to all employees from the moment they are hired, and a good practice is to provide reminders of the importance of following such policy. Number 3, training employees and managers on avoiding sexual harassment. At Marriott, for example, we do require for all new hires to complete a harassment prevention training during the first 30 days of hire, and a recertification every other year is also required. And that actually is a new requirement in California. Number 4, take it serious. Make it a priority. If a claim of sexual harassment comes to you and you are a manager or a human resources representative, make sure that you have a process in place to investigate the claim effectively and to offer a solution, which should be communicated to the claimer and all the parties involved. Before you continue, pause here for a moment and take the opportunity to review the attachments provided on Blackboard for this week, which are tools that might be very helpful during an investigation. The attachments that I would like you to review at this moment are the investigation checklist, post-investigation letters, and the difference between harassment and unlawful harassment. Once you finish reviewing those materials, you can continue. Several federal laws have been enacted to advance the employment of disabled individuals and to reduce discrimination based on disability. Some of these laws are the Rehabilitation Act, which was passed in 1973, applied only to federal contractors, and it is the earliest law regarding disabled individuals. Almost 2 decades after, the Americans with Disabilities Act, ADA, was enacted in 1990. This act applies to private employers, employment agencies, and labor unions with 15 or more employees, and it is enforced by the EEOC. State government employees are not covered by the Americans with Disabilities Act. Please take a look at some other attachments posted on Blackboard, which are tools that can be used when an employee with a disability requests an accommodation. The attachments that I'm referring to specifically are the Interactive Discussion Accommodation Request document and Reasonable Accommodation and Interactive Process Checklist. A reasonable accommodation can become a very gray area, especially in states like California. So, Before denying an accommodation request that might seem unreasonable to you, make sure that you have consulted with your human resources or legal department in order to make a determination that is aligned with the law. So take a moment to review those attachments, and when you are done, please continue. There are other laws and relevant concerns covered on your textbook, including the age discrimination laws, the religion and spirituality in the workplace, Immigration Reform and Control Acts, language issues, military status protection, and also appearance and weight discrimination. Please ensure that you also become familiar with those concepts, which are part of this week's content. And this concludes the last video of week 3. So what is next? Please submit your initial post in the discussion board for discussion number 4 before Wednesday. The discussion is titled Harassment and Discrimination Prevention in the Workplace. Also, read chapter 3, Workforce, Jobs and Retention of the textbook, and then complete quiz number 3. As a reminder, you need to respond to at least 2 classmates by the end of the week on the discussion board for this week's discussion in order to get full credit. Enjoy the rest of your week, and I can't wait to see you again next week so we can continue learning together.